Hi, this is Fred Neiman of Hanlon Neiman, practicing elder law and estate planning in all 21 counties of the state of New Jersey. Interesting question often gets asked of me, and that has to do with changing the last will and testament or revocable trust of a person who has now been declared incapacitated. Oftentimes, the aging person has signed a will or other document, perhaps a power of attorney, that goes back 10, 15, 20 or more years. At the time it was originally signed, the person was of sound mind, understood what they were doing and the consequences of what they were doing. Over time, that capacity has changed to the point where now it's pretty much conceded that the person really doesn't understand what they're doing and what's in their best interest. So, in order to further what was the stated intention of the now incapacitated person, I'm asked, can we make changes to those important legal documents that were good but now are not so good? And my answer is very much consistent, and that is probably not. A last will and testament cannot be changed. It cannot be rewritten by a power of attorney or a legal guardian. A revocable trust, likewise, cannot be amended, cannot be rewritten or materially changed if the person is incapacitated, unless the trust document speaks to authorizing the trustee to make those choices, make those changes in the trust document. What's critical in all of these documents is how much authority was the agent given. Are there circumstances under which the documents would give authority to the agent to do things on behalf of the principal? The answer is clearly yes. Can asset protection planning be done? Yes. Can life care planning be done? Yes. But can you create a whole new will that materially differs from the terms of the original document? Most likely not. There is case law in New Jersey which has addressed this subject. What we oftentimes try to do is write documents when the person is of sound mind, who has legal capacity, anticipating that that may not always be the choice or the circumstance, and what we'll do is we'll put specific powers in there that allows their representative to do what's in the best interest. And we try to create some standards so that the actions of the representative are not adverse to or inconsistent with what was the stated intentions of the person during the course of their life. So if you're faced with that situation where the family member or someone close to you needs protective action, some of the initial documents are now outdated, changes should be made, come in and see me, we'll talk about it, we'll see if there's ways to implement your thoughts, to try to take that protective action. If not, again, depending on a guardianship, if that's been done, we can look to see whether that might solve some of the problems without having to do nothing and allowing the incapacitated person's estate and or interest to go spent down or otherwise impoverished. This is Fred Neiman of Hanlon Neiman, elder law firm in Freehold, New Jersey, practicing elder law and related estate planning in all 21 counties of the state of New Jersey.